When would you get into a screaming match with a defense attorney during a deposition? Would you like to learn the answer? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. In a deposition, which is a question and answer session given under oath, I have an opportunity to question the witnesses that you have sued in the case. During the course of questioning, there may be disputes about whether or not the witness can answer certain questions. Now, in New York, lawyers are supposed to treat other adversaries and their colleagues with civility. You know, years ago, in the old days, lawyers would get into big screaming matches in the middle of a deposition where we're trying to question a particular witness in a particular lawsuit. Over the course of years, the court system realized that this is ridiculous. You know, it should go without saying that lawyers should treat their colleagues and adversaries with civility. It creates an overall ambiance that really can affect how the litigants feel during the litigation process. So over the last few years, the courts have actually implemented and standardized the rules that are required for attorneys in the state of New York. And in fact, there was a big push a number of years ago for lawyers to be civil to their adversaries, even though you may disagree with their stated legal position. Now, during the course of a deposition, disputes will certainly arise about whether or not a witness can or cannot answer certain questions. However, each side is required to act civil toward their adversaries. And if they don't, there's a real possibility that they could be subject to sanctions and fines by the judge who is overseeing that particular case. Now, recently, when I was questioning a doctor, I had a defense attorney who was getting under my skin. This attorney was pushing all of my buttons, and I think intentionally. And they were making comments designed to get me to act and to get me distracted from what I was trying to focus on. I'm pleased to say that ultimately I was able to get all the questions out that I wanted and all the information I needed. But this was a clear tactic designed to interrupt my pattern, interrupt my thoughts, and just to get under my skin. And after quite a bit of interaction and yelling with the attorney, we came to an understanding that this simply was not acceptable. And if this attorney continued to proceed in this fashion, not only would we go ahead and call the court, but I would make a request for sanctions and penalties against this attorney for the actions of what this lawyer was doing. So why do I share this information with you? I share it with you just to give you an insight and an understanding in what goes on during the litigation process here in the state of New York. You know, chances are you have questions and concerns about your own particular matter, and you want answers to your legal questions. Well, here's what I encourage you to do. Pick up the phone and call me. I answer legal questions like yours every single day. And you can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.